On PM Express tonight, the EOCO versus the Auditor General, two powerful state institutions clashing on the subject of corruption and procurement breaches. But the real questions to ask on the back of what has transpired so far is it a witch hunt or a genuine probe? We're going to try and break that down for you tonight on the show. Now, that is the man at the center of the storm, Daniel Demilabo. EOCO says, they are probing him. He says they have absolutely no legal basis to subject him and his officials to this probe that EOCO is undertaking. Now, it has been better about EOCO's probe of him and his outfit for alleged procurement infractions. Now, his deputy in charge of finance is also part of this probe in terms of the scrutiny that EOCO is bringing onto them. And the Audit Service Board have been accused of circumventing the procurement laws to procure some vehicles for the audit service. This is 6.2 million cedi worth of vehicles purchased by the audit service generally. And of course, he's at the helm of that service. And of course, then he takes the blame for it if something goes wrong. Now, a petition, this all was triggered by a petition from a private citizen to EOCO, claiming that, among others, that the audit service had breached the Procurement Law Act 663 in the procurement of the vehicles, right? Now, the petitioner requested EOCO to determine whether proper procedures were followed by the Entity Tender Committee, which is a committee which you find in many of the civil society organizations, or civil service organizations, where these entity committees, state organizations, state agencies, where these committees operate to scrutinize some of these purchases before they go through. And they want a recommendation which is appropriate and sanctions as well in accordance with the Public Procurement Act 663 where necessary. Now, the AG argues, and AG is the Auditor General himself, Mr. Daniel Demilabo. He argues that the relevant provisions in the Act that sets up the Special Prosecutor has taken away the powers also of EOCO to investigate corruption and corruption-related offenses, including procurement breaches. And his fundamental argument, Daniel Demilabo's fundamental argument is, you no longer have the power to do what you're doing, to purport to probe me for alleged procurement breaches, because that is no longer something that the law allows you to do. Now, he describes the situation as, quote, quite bizarre and unfathomable why EOCO will purport to investigate procurement breaches when it does not have any legal authority to do so. From the horse's own mouth, in a statement that he issued just yesterday. Well, this is a statement that was issued directly to the EOCO that, of course, we got a copy of, which is the subject of this same conversation on PM Express tonight. Now, he's asking EOCO to stop investigating him, not just that, but also apologize to him and his staff for putting them under the spotlight and simply wasting your time. He says he actually drove there once out of respect for EOCO, and then he ended up being cautioned and then had to be bailed by his driver. And that is why he's upset. You can hear that in the tone of the letter that he wrote to EOCO. Well, we are getting some reaction from EOCO tonight. They've been speaking to the Graphic newspaper. I'll share that with you. They are calling his bluff, the bluff of the Auditor General. But the fundamental question remains. The Auditor General believes there may be ulterior motives behind the EOCO investigations. In fact, he believes, he said this on the Super Morning Show, that he believes there is an attempt to cripple him. He won't mention names, but he says if you fight corruption, corruption will fight back. Is that what is happening? Is this a witch hunt or a genuine probe? Stay with us. We'll attempt to answer that question for you on PM Express tonight. You're live on PM Express. My guest in the studio is James Klucha-Veggie. He is the Deputy Minority Leader, but also the Chair of the Public Accounts Committee in Parliament. That is the committee that has the supervisory jurisdiction over the Auditor General. When the Auditor General does his work, he reports first to his committee, and so it's just appropriate. And when you're talking about his office and his suspicion that there are people out to get him, you speak to the man who has the power to supervise his work, and the chairman is with us on the studio. Thank you very much, Mr. Veggie, for your time on the show. Also joining us is a private legal practitioner and also lecturer at GIMPA, Justice Stremsai. Thank you very much, Justice, for your time. Also joining us on Skype tonight is the former executive director of the Ghana Integrity Initiative. After all, this is a corruption or anti-corruption conversation. You can't have it without one of those staunch voices from that particular fraternity. Vitus Azim is also on Skype tonight on this particular conversation. I want to start with a legal question, because if you read the Auditor General's letter to the EOCO, he is basing his position that EOCO does not have the power to probe him on a legal question, which he says his lawyers have advised him on. Now, the thing about his position, though, is that he says the powers of EOCO to investigate corruption and corruption-related offenses, including procurement breaches, have been taken away from them based on amendment of the law. Is he right legally to espouse that position? But tonight, Graphic is reporting that EOCO has a response to him, in essence, dismissing his position, calling his bluff. I'll share with you what the deputy EOCO boss, the acting EOCO boss, has been saying to Graphic shortly. But Justice, the legal question, I'm sure you've seen his letter, quotes two laws, one on EOCO and the other one, I think, on the special prosecutor. I think his argument there is that the special prosecutor's law seemed to have, there's an amendment in there that had taken away the EOCO's powers, and so EOCO does not have the power to investigate. Is that the case?
Yes, I think that is the case. There are two principles of law that we can use to justify his position. The first one is that when two laws, one speaking generally and the other one speaking specifically, the one which speaks specifically, would override the one which speaks generally. That is one. The second one is that when two laws, one earlier and the other one later, are saying the same thing, and there's a confusion which one survives, it is the latter one which survives. On these two principles, then the Special Prosecutor Act, tends to override the EOCO provision, granted. But what is even in addition to what these two principles say is that there's an express provision in the Special Prosecutors Act which deletes the power that allows the EOCO to investigate corruption and bribery. That is the expression. Now, no creature of statute has omnibus powers or has powers that are unlimited. That's one cardinal principle of constitutionalism. Once the law creates an institution, it gives it powers, and then it circumscribes the power as to how and when it should be used. Now, the functions of EOCO says that they can investigate serious offenses. Then in the definition section of the Act, they specify what serious offenses are. We have child trafficking, human trafficking, money laundering and all. Then we have bribery and corruption. Now, this bribery and corruption is what EOCO seems to be standing on to investigate the Auditor General. Now, the Office of the Special Prosecutor Act, which came later, specifically assigned to the Special Prosecutor the power to investigate corruption in relation to the Procurement Act. Now, we understand that EOCO's investigation is in respect of some procurement breaches of some concerning some purchase of vehicles worth
6.2 million.
2 million. Now, if that is the case, and if that is what EOCO is actually investigating, then it appears strongly that the argument being made by the Auditor General is accurate. And if it is accurate, the good thing here is that the Auditor General is not saying that I am beyond investigation. He is not resisting investigation. All what he's saying is that there is a properly constituted body or organization which is supposed to investigate him and not EOCO. So I don't see, honestly, I don't see why there's a tussle here. Especially in the Special Prosecutors Act. It specifically provides for situations like this. So if you look at Section 81 of the Special Prosecutor, it says that institutions that are already investigating, like EOCO, specifically mentioned EOCO, should transfer, cases that were under their jurisdiction, but which now fall under the jurisdiction of the Special Prosecutor, to the Special Prosecutor to investigate. So it's just a question of the EOCO, leadership, understanding that these are what's at stake, and then transferring the file or the docket to the Special Prosecutor.
They are not mandated under the law, are they, to make that transfer?
They are.
They are mandated?
Yeah, the Special Prosecutor Act specifically says that.
They should.
Yeah.
Do they have the power, though, to investigate this particular type of alleged breach? EOCO, under the law that sets them up.
My reading of the law, the two laws and what I know, I mean, they don't.
They don't?
They don't.
When Domelevo talks about has been amended, in fact, I want to read exactly what it says. I'm advised that the relevant provision Act 959, which amended Act 804, is Section 80, and therein, your office's mandate to investigate corruption and corruption-related offences, which has been defined to include procurement breaches, has been taken away. Is that true? Has it been taken away, or it just
it's been taken away expressly?
Expressly?
Yes, there's an express provision which deletes that mandate.
Okay, that's interesting. What's your that is a legal point. I mean, I must say that there are people who disagree with this legal position.
Of course, I mean, that's what
Max Opoku-Agyeman, for example, who was the lawyer in the case against Charlotte Osei, same procurement breaches cases. That case that was brought that led to her removal. Disagrees with that position.
I would have loved to see his reasons.
His reasons, yeah. We'll see if we can get him, because we tried to speak to him to see if he can speak to us on that. But you're the chair of the Public Accounts Committee, a man you supervise, an institution you supervise. In fact, his position when he was on our show last week is that he is being unfairly treated and targeted because of the job that he is doing. But some argue he's been investigated. He's a man who does all the investigation. Now that he's been investigated, he's crying.
Well, first of all, let me say that the Auditor General doesn't do investigation.
Okay.
What he does is auditing. Because if you look at Article 187 of the Constitution, which establishes the office of the Auditor General, it says that there shall be Auditor General of Ghana, whose office shall be a public office. Now, his function is to audit all government. Let me quote what it says, that the public accounts of Ghana and all public offices, including the courts, the central and local government administration, the universities, the public institutions of like manner or like nature of any public corporation or any body or organization established by an act of parliament shall be audited and reported on by the Auditor General. So he is the one established by the Constitution who has the power to audit the accounts of Ghana, either local, central, universities or whatever, court or whatever. He does all this audit and report to Parliament. So first of all, that is the power of the Auditor General. Now, he can do that also by engaging the services of auditors. The law allows him to do that. So most of the corporations that we have, public corporations, the Auditor General engages the services of the auditors, private auditors, to audit and submit report to him, that he then owns that report and submit the report to Parliament. Now, the Constitution also says that whenever he finishes audits, by June or by 6 months after the end of the year, he must submit his report to Parliament. Now, when the report is submitted to Parliament, that report must be laid in Parliament. Here, because the Auditor General doesn't come to Parliament, to the floor of the House to lay, it is usually laid by the majority leader of Parliament on behalf of the Auditor General. Now, when this report is laid, report is then referred to the Public Accounts Committee. That is why we as PAC members go into action to review and then call the people who have been cited in the report to question. Now, we also issue reports to Parliament, and once that report is adopted by the entire House, it becomes the document that the audit committees have to work with. So the Auditor General, per se, if he is the one who audits, he doesn't investigate. Then the issue about whether he can also be investigated or not, legally, I don't think that he is above the law. But he is the one who does the auditing and then submitting report. Now, how is the Auditor General funded? Now, if you read the Constitution, it was very clear that the expenses, the allowances, the salary of the Auditor General and his office is a charge on the consolidated fund. So what it means is that a month to the end of before the budget is presented, the Auditor General or the board must submit estimates of expenditure for the office of the Auditor General to the President. And the President has no power to review that figure. That is why it says it's a charge on the consolidated fund. He can only make recommendations on that to Parliament. The Parliament will then say that, look, the Auditor General is asking for X amount of money to run his office for the following year. The President is making a recommendation that it should be X amount of money minus Y. What do we do? Then we go into discussion and say, okay, let's accept what the Auditor General is submitting or what the President is submitting. So that is why it's a charge on the consolidated fund. So all the activities of the Auditor General, the salary, the administrative costs, whatever expenses, is a charge on the consolidated fund. Now, the release of this fund, the Finance Minister has no power to say that this is the amount that Parliament approved for the Office of the Auditor General. For that matter, there is no money available, I will not release to you, because it's a charge on the consolidated fund. He must, anytime the Auditor General needs money to do his work, he must release the money. But most of the time, what we see is that there have been some kind of frustration in a way where the Auditor Generals are not provided with their resources all the time. So basically, that is what the Auditor General is. Now, my committee worked with him. Now, when the report is submitted and referred to the Public Accounts Committee, and when we go into action, most of the time, what we do is that we first meet with the Auditor General, that you have made ABC recommendation in the report. Take us through the processes that you made it to arrive at that recommendation. Then the committee member will understand clearly why certain recommendations are made by the Auditor General. Then we then invite the officers or the civil servants that have been cited in the report, we invite them. There also, we always have representatives of the Auditor General to sit in the committee hearing. And where an officer who has been cited says that, oh, I have taken action on that recommendation by the Auditor General, we have to get a confirmation from the rep of the Auditor General. So basically, this is how we do.
This is the structure. But here's the case where the man himself, one of those duty bearers when it comes to dealing with corruption, he's a subject of an investigation by another state agency, EOCO, and he's claiming that they don't have the power to investigate him. Why doesn't he simply, because this is, corruption must be fought, but it's also a perception issue. In fact, I want to go to Vitus Azim on this one because he's on the line with us. Mr. Azim, corruption must be fought, but not only be seen to have been fought, but in reality, but also the perception and the way it looks is also very important. Here we are where one of those chief fighters of corruption, at least the way it looks, some have argued and spinned that he doesn't, when he's accused of corruption himself, as in breaching procurement rules, he's running away from responsibility and hiding behind laws to say, you don't have the power to investigate me. What's your reaction to that, those who hold that view?
I think the situation is very clear. The man says that EOCO hasn't got a mandate to investigate him. He's not saying that he doesn't want to be investigated. Everybody, if you're accused of allegations of, if you're accused of corruption, you are entitled to be investigated. So it is not that, from my understanding, it's not that he doesn't want to be investigated, but he thinks that EOCO hasn't got a mandate to investigate him. And the lawyer there has spoken. It is clear the Office of Special Prosecutor is there. If you're not happy with Office of Special Prosecutor, Shrag is there. You don't have to insist that EOCO should investigate the guy. This is the situation, the way I look at it.
But here's the thing. What is wrong with simply submitting himself to the EOCO process? What will he lose?
He has already submitted himself to the EOCO process.
But he says he will not.
But the way the thing had, no, he's gone to the EOCO office. Yet, I mean, when he got there, what did they do? They decided to arrest him and ask him to be bailed.
Yes.
That already raises eyebrows. This is the head of an institution that is performing similar roles like you. Then you invite me to question me, and all of a sudden you tell me that I have to be bailed. Who means you have arrested me? So that already gives an impression that there's something that is happening, cooking. And so if he thinks that the EOCO doesn't have those powers, I think it's only fair that he insists that the right institution investigates him. He's not saying they shouldn't be investigated. That's not how I see it.
Now, Chairman, I want to read something to you that Domolevo says in the statement. It says, where staff of our service and I are ready to submit ourselves to investigation by appropriate authorities, I am advised that you have no basis to investigate or continue to investigate me. Then it goes on to state that because they don't have the power, when and in fact it does not have any legal authority to do so. In fact, I want to read this properly within the context so you appreciate where he's coming from. He says, this clearly means that your office does not have the jurisdiction. After he quotes the law, it is quite bizarre and unfathomable why your office will purport to be investigating procurement breaches when, and in fact, it does not have any legal authority to do so, unless, and this is the part I want to emphasize, unless there is any hidden or ill motives behind your actions. Is that a fair point to make from a man who, why is he reading ill motive?
First of all, I do not think that there is a conclusion that there is a procurement breaches. There is an alleged procurement breaches. So that should be corrected. That if the man is alleged to be breaching the procurement law, and then also he again saying that the EOCO has no mandate in this matter to investigate him. Don't forget that he has already submitted himself to EOCO. When he has no information or that knowledge that the EOCO has no mandate. So it means that the man is prepared to be investigated. So having submitted himself for investigation, and on submitting myself to the investigation, you arrested me. Which means that there is some hidden agenda.
Why? That's what law enforcement agencies do.
Look, submitting myself, then you arrest me.
Yes.
I am not resisting that investigation. Then by moving to your office to say, hey, I'm ready for you to investigate me, then you arrest me. So, and why all this? You know, there is background to all this.
What's the background?
It has been alleged that because of the work that he's doing, where the Constitution mandates him to disallow certain expenditure and say charge officers who are involved. Because if you read the Article 1877B, it is there, clear, that first of all, in performing his duty, he is not subjected to any direction of control of any person or authority. That is one. Then he may disallow any item of expenditure which is contrary to law. Now it has been alleged, or this issue about this crow payment of $1 million,
which has pitched him really against the senior minister.
Against the senior minister. You think that, look, if he's doing that, either he's witch hunting or what, is it doing within the law? Does the law say that if there is a payment that is against the law, the financial administration law, that person can't be surcharged. That payment can be disallowed. If he's doing that, why don't you submit yourself? Why do you want to think that the man is being an obstacle? And so, if that is not the issue, then what is the issue? That's the Auditor General submitting himself to be investigated. Then you pick him and then arrest him.
But nobody's above the law, you said so yourself.
Yes, I said it.
Yes.
Nobody is above the law.
So
That is why he is not resisting the investigation. That is why he walked to the office to submit himself. That come and investigate me.
Justice.
Evans, EOCO, as we know, is investigating an institution. So, in situations of investigating an institution or an organization for criminal purposes, there are two levels. First, you need to establish the organization's, fault. Then you go to the next level of, pinpointing the individuals who are responsible. I mean, Auditor General, the audit service is huge. So granted that there is some wrongdoing, criminality, I think you can't just on the first instance pinpoint the head of the service as personally, liable.
Ultimate responsibility.
Oh, yeah, but crime doesn't operate that way.
Yeah, but
yes, I may be ultimately
that authorize the purchase of the vehicle.
There's an element of crime. There's an element in proving crime, which is the intent. Intent is not intent in criminal law is not. It's usually not the ultimate responsibility that you seem to be referring to. I should be, the individual, a human being should have that intent to do the thing. So I was worried that he would be cautioned at the first instance. But then again, it may happen that, well, they have done their investigation and they are sure that he personally did it. Fine. The issue here, however, is the man is raising issues about your good faith. I mean, and I think that issue should not be treated lightly. The good faith in the sense that to arrest someone and to call for the person's bail, I don't know what transpired between him and the people. I don't know what evidence they showed him.
Yeah.
I don't know what happened in there. But his objection is not just about emotions or feelings. He has pointed directly to some objective basis, which is legal provisions that you and I have read. And as you can see, many lawyer seem to agree with
those are fair points, but is it fair for him to impute
why
ulterior motives to EOCO?
I think motives are part of human analysis that we all make every day. If I analyze the objective facts, okay, and it's not pointing to the treatment you are giving me, then I have to ask, why are you...
What is wrong with the treatment? You simply go to the place, they arrest you, they caution you, and grant you bail, which is standard procedure.
No, it's not standard. No,
it
is not standard procedure that anytime someone is invited to a police station, he has to be arrested. No, it is the last stage when there is sufficient. It is actually the last stage.
Law enforcement agencies can arrest you on a reasonable suspicion. Reasonable suspicion. But here's the case where the vehicles have actually been bought. Allegation is that there's a breach.
There are different types of crimes. Okay, there are crimes that you will be arrested immediately. We even see you there. This is procurement. It's not felonious. It's not the crime that the person is not a threat to anyone. So the arrest. So there are a range of crimes that you don't need to do. In fact, some crimes you never arrest the person until you even go to court and all that. So I think we should look at the thing within the broad picture. And here we are having instances of he investigating very powerful people. And I'm not saying that if you investigate powerful people, then you have insured yourself against investigation and arrest. But if you put the whole scenario into context, I think the motive will not be as frivolous as we would like to.
I want to bring inviters on this, and I'll come back to you, Chairman. Mr. Azim, I come back to this motive question. You have been in the anti-corruption space for so long. If you're accused, if this wasn't Daniel Demelovo, we know his track record in fighting corruption. Anybody else, if it's not Daniel Demelovo, and anybody else has been accused of corruption or breach of procurement laws, and the person then questions the motive of the agency that is investigating him on this, as anti-corruption campaigner, won't you raise questions about why your first question is motive? Submit yourself to the process.
I think that the issue is not if it is not Demelovo. It is Demelovo. The role that he plays the role that he's played, the things that he has done, the statement he has made publicly about not yielding to any pressure from anybody, that he's going to do the right thing. The people that he has been, taking action against. So you cannot say if it's not him, it is him. It is because he's Auditor General that he's being investigated by EOCO. So that's one.
Sorry, forgive me. You say it is because he's Auditor General is the reason why he's being investigated by EOCO. That's a strong statement to make.
Because he has been invited in that capacity, not as an individual Jomeluwo. Or don't you see that?
Yeah, I mean, but it's not. But it's almost the link there. It's not because he's being invited because his office bought vehicles that allegedly breach procurement laws. Anybody would have been invited. It just happens to be him and his office.
It happens to be him, but they wouldn't have invited me because I'm not involved in audit service. I haven't bought any vehicles. So you cannot separate the two. He's invited because he's head of audit service. He's probably not personally involved, but because he's the head of the institution, that's why they have invited him. That's one.
Yeah.
The second thing is that he's not refusing to submit himself to investigations. He's only saying that EOCO doesn't have the mandate to investigate him.
I mean, some say it's fair to say that, but is it fair? It's fair to say that, but is it fair to impute wrong motives?
I think I've responded to that already.
Yeah, I mean,
it is only fair. If a human being is fair for him to impute, because, as I said, you invite me for the first time, and the lawyer has said it there, and then you tell me that you are arresting me, I have to get somebody to bail me. That already clearly shows that there is a motive. You cannot rule out the fact that there's a motive. If it were you, the police just invite you to the office to ask you questions, all of a sudden they say, oh, we're arresting you, get somebody to bail you. If they had told him that he would have come with a lawyer, did they make it clear to him that that was the level they were going? So why won't he suspect? Why won't he suspect that there's a reason?
What motive do you suspect yourself?
Well, you see, if you are fighting corruption, you are always in the danger of being intimidated. And I don't have evidence, I suspect that that is the only reason. And when you are dealing with people in high positions, you should expect that kind of behavior from people that are directly under the executive. EOCO is directly under the Attorney General, who is under the President. These are suspicions. We don't have evidence, but these are suspicions. And the general feeling is that this is a strong man that is trying to fight corruption, to bring people that have faltered the law to book. And everywhere, globally, such people are always in trouble. People are always trying to put them into trouble so that they don't execute their mandate effectively. And so we said that if EOCO doesn't have a motive, they should transfer the matter to Office of Special Prosecutor to handle. After all, the Special Prosecutor said that they have been collaborating with EOCO. So pass the documents to Office of Special Prosecutor and collaborate with them in the investigation.
I see.
That would clear the situation.
Chairman, something that maybe you'll be aware of. Daniel Domolevo was on this same show earlier this year, and he was full of praise for this government for the swiftness with which they had provided and released resources to him. In fact, he says it was unprecedented that for the first time in a long time, they've raised the resources by a certain level, and they have given them almost everything they need to work. If that is true, and you could confirm because you supervise the disbursement, etc. If that is true, and Vitus's point is true that you're fighting people in government, and you've also suggested the same. If that is true, why would that government, the same government that releases all the funds to him in good time and in good measure and has increased, why would that same government turn around to cripple him and witch hunt?
I don't think that there's a link between the release of the resources and the report that same person will issue on you. If by releasing the resources to the person will mean that whenever he is issuing his report, you should consider the fact that because the resources are being released to me, I should not come up with certain issues that I found out in my audit. He is not the type who would do that. he will go ahead whether, because look, I said it earlier on that the Constitution made the expenses of the Auditor General a charge on the consolidated fund. So for that matter, if the finance minister releases his resources to him, that is not anything extraordinary.
No, but the point is, in the past, it hasn't come the way it did this government.
I agree with you that in the past it does not come that way, but that also means that if
that is a friendly government to him.
Yeah, so it's friendly. So if there is any corruption, if during the course of the audit he found out that that government that releases resources to me to audit, I have found out that certain payments have been made unlawfully, I should not talk about it.
So he did.
So he did. That's why I said there's no link between the release of the resources to him and the report that he turned out.
No problem. So he releases the report. I'm just coming to the point about the suggestion. First of all, let me ask you a point-blank question. Do you also believe this is a witch hunt?
I believe to some extent, because if you look at the power of the Auditor General to disallow and surcharge officers who either incur the expenditure or authorize that payment, that is not final. So if the Auditor General surcharge you, there is provision in the Constitution that allows you to challenge that surcharge in court. So if certain people who are with high powers are being surcharged because the payment that they have made to certain companies, they could go to court to go and challenge that disallowance or surcharge.
He's written to Odawolo to tell him that it's...
No, there is a provision in the law, the time frame within which you should do that. You don't wait until the time passes and the Auditor General take action, then you downright. No, it doesn't. Look, we are being ruled by law, so we should all follow the law. You have 30 days after the query on you by the Auditor General to respond. So if you don't do that, after 30 days, the Auditor General can go to court. Now go to court to go and challenge the surcharge. And if you're not doing that, then you think that maybe there's a way that we can level allegation against the Auditor General and probably investigate him and then find him guilty. And for that matter, it's a stumbling block on our way. Let's clear him out. I suspect that there's some element of targeting.
Targeting. You call it witch hunt?
I call it targeting.
Okay, I'm going to take a break. I'll come back to you, Justice. I'll come back to you, Vitus Azim. When I come back, the graphic is reporting tonight that the EOCO is responding to the Auditor General. We'll share with you what they've been saying, but also the fundamental question remains. If Daniel Demelobo believes that the EOCO hasn't got the power, why is he interpreting the law when he can go to court? That's not his domain, some have argued, to be interpreting law and claiming another institution hasn't got the power. He should simply go to court. Why is he not taking that option? Stay with us on PMS Press. So live on PMSS. My guests in the studio are still Justice Stremsai. He is a private legal practitioner. Also with me is the chair of the Public Accounts Committee, James Kluchaveji. And on Skype is Vitus Azim. He's a former executive director of the Ghana Integrity Initiative. Graphic is reporting tonight that EOCO's acting boss has spoken to them. That is Mr. Edupoku. And he says, when he asked him about this, he says he confirmed receipt of the letter, but says, but if he, the Auditor General, has any difficulty with our mandate, he cannot sit in his comfort of his office and proffer his own interpretation to suit his whims and caprices, he told Mr. Demelobo. He goes on to say that that interpretation, if any, should be done by the court. He said, we are preparing a fitting response to him. EOCO has a point here, don't they? That if Daniel Demelobo cannot sit in this room and proffer interpretations on legal matters, you should go to court.
I think court should always be the last, resort. It could be a genuine omission on the part of EOCO that they did not advert to the point he was making. So writing administratively to a colleague or a sister institution that, look, can you reconsider this position? I don't think it's something out of the ordinary. That is actually what's supposed to happen.
No, he's asking EOCO to stop investigating him.
Yeah, I mean, he's
EOCO definitely will not stop investigating
He's
him.
objecting. Well, they may decide not to, but they should be telling us why they won't. I mean, they should be justifying why they will insist going on with with all these explanations that he's giving. Of course, I don't think Mr. Domelevu, when he wrote that letter, was intending to command them to respect or to obey his orders. He was only drawing their attention to something that they could have probably not paid attention to. Now, if their decision is that they've also now considered it and they believe that they still have the mandate, then the ball is in Mr. Domelevu's court to go to court and restrain them. Because EOCO can also say, well, let me continue doing my work as I believe I am entitled to do. When they do that, and so Mr. Domelevu or the audit service can go to court to restrain them. But back to the issue of motive. Before I came here, I didn't think there was any basis for the motive. But after listening to the explanation, it appears that if you look at the bigger picture, if you take a step back and you see the bigger picture, the motive he imputed may not be frivolous at all, may not be frivolous. And I believe that once that comes in as administrative setup or state, we need to respect these boundaries in terms of what we can do and what we cannot do. And the fact that once there are other competent institutions that can handle this matter, I think, why not? The man is not saying that don't investigate me, he's saying that you don't have the authority. And that has to do with crime. In criminal law, this can actually thwart the entire process. If you do something that you don't have power to do, the outcome will not be accepted. And this is where I expect maybe the Attorney General to step in, because there's actually provision in the law which gives power to the Attorney General to resolve some of these issues. And more so when EOCO is under the Attorney General's direct supervision and control. So the Attorney General probably needs to speak on this matter, because she has the mandate to resolve this particular issue.
This matter was taken up by EOCO based on a petition, right? Yeah. Maxwell Poku-Ajuman, who has also already been the lawyer that led to the removal of another equal in Dana Domelevu, as in the chairperson of the Electoral Commission, has suggested that the petitioner in this case probably took it to the wrong forum. He said the petitioner in this case should have used the basis of his or her procurement allegations and trigger the constitutional clauses and petition the president and trigger the processes for a formal removal of Dana Domelevu, so that then the matter is then forwarded to an appropriate agency, which is, I guess, the Chief Justice, for a proper probe into this. That will then lead, because what is happening right now with the procurement breaches, with investigation of EOCO, doesn't really lead to much. What's your view on that?
No, I have always maintained one position on these issues. You see, removal from office for misconduct should not be interpreted to mean that any anomaly, any mistake, any error, any wrong that a person does in office could lead to his removal. And I made this same argument when in the Charlotte situation. I don't believe that every wrong should lead to removal from office. Yeah, every administrative wrong. If that's the case, then I don't know what will happen.
No, but if 6.2 million of taxpayers' money is used to buy vehicles and it did not meet procurement breaches, it did not meet procurement regulations, possibility there. The reason why procurement law is important is that such taxpayers' money is not misused. The possibility that money may have been misused, that is enough grounds to remove somebody.
Yeah, but as at now, you see, when you petition for someone's removal, there are grounds stated there. It doesn't include
stated misbehavior.
Yeah, it doesn't include, other. You see, interpreting these issues, okay, you if there are grounds stated, of course, the lawmakers could have specified that, well, if you do X, Y, Z, but they said stated misbehavior. Stated misbehavior means things that are not expressly provided for someone. When I commit a wrong in respect of a particular law, and there's a remedy there, I think the general view is that that remedy should apply.
But I think now there's a precedent, so I think that argument is settled.
Well,
Because Charlotte said procurement breaches led to her removal.
Was it tested in court?
As in
that issue was not.
Yeah,
was not
Kuku Bako went to court.
Yeah, but that was
and
not,
lost.
But that was not his argument when he went to court.
Whether the substance of the
well,
I mean that's an area that is
it's an area that
I'll come back to you, but let me go back to Vitus Azin. Vitus, fundamentally, this is two anti-corruption bodies clashing. How does this affect the fight against corruption?
It is very unfortunate. I think that these are two state institutions paid with taxpayers' monies to fight the same crime. They should have been able to settle this thing and refer the matter to the appropriate institution to investigate. As the lawyer justice said, the court should be the last resort. EOCO has a law that set it up with the various amendments. Go back and look at the law and see whether the Auditor General has a case or not. If he has no case, if he has a case, you refer to EOCO. You refer to Office of Special Prosecutor or SHRAG or whatever. But if he has no case, then you insist on this stand. In the same way, the Auditor General should look at it again. If he has no case, then he should submit himself. But if he has a case, he should proceed. But the fact that these are two state institutions that are supposed to be doing similar work are encountering this thing, it raises a lot of eyebrows. And it is just not possible. It's not a good thing for the two institutions, the integrity of the two institutions. Can you imagine that the Mlevo goes to court and the court rules in his favor? How would EOCO feel? EOCO should put them, the executive director of EOCO should put himself in the position of the Mlevo. If the Mlevo had come to audit his office and had the powers to arrest him and then invites him to discuss the audit report, and all of a sudden he says that you have to get somebody to bail you, how would he feel? So these are the issues that we should be looking at. We are human beings. We have to treat each other as human beings. Yes, he should submit himself to investigation, but the way they are handling the matter is not the best. And in any case, the laws are there to guide the two of them. The EOCO has a law that has been amended. Look at the amendments. Alongside the law that set up the Office of Special Prosecutor and see whether you have a case or not. That should be the end of it. I don't think that this thing should be dragged.
Well, Chairman, so my final question, I'm sure you have final thoughts also, but the final question to you, so you have supervisory decision over his office. If, as Vitus has said, his work is impeded by this probe, and he himself believes this is something on the lines of a witch hunt. He said that's mass march, and there's ill motives, etc. Is this something that your committee is allowed to do?
Come again.
I mean, if this whole probe affects his work as Auditor General, this is a person work you supervise, and his work is impeded. Because in fact, he's been saying that for the last few weeks, they've been inviting him every day. So his officers and staff are not able to do their core mandate, which, they report you. Is this something that you're allowed to do if you find out that his work is being impeded because, there's all this?
If the process will lead to his work being impeded, what it means is that the fight against corruption will suffer. Because it means that the Auditor General will not have that freedom to do the audits and ensure that the civil servants or the accounts of public accounts of Ghana is properly done in accordance with the law. It means that most of the issues that he is coming out with in his audit report will people or officers, civil servants who are actually working on this with this account will have the freedom of kind of sort to do certain things that will go against the law. Because the current Auditor General, it's because after the court ruling on the surcharge has started implementing this surcharge, and our committee also is enforcing that. So it is making the civil servant now very alert and ensure that if the recommendation of Auditor General is for you to make certain payment to government, quickly they do. before even the Public Accounts Committee calls them. Now, if his work is delayed or is affected by this, then it means that all this effort that we are making to ensure that public servants, civil servants do not go into corruption and steal public funds will also suffer. And Ghana as a whole is the one that...
Knowing Dana Demolavo, the one man you've been having on your committee for all these years, you think he'll be affected by this?
I don't think so. I don't think so. In fact, the letter he wrote to the EOCO, the acting EOCO boss, he's saying that they are going to respond.
Yeah.
Now, Demolavo quoted sections of the Act, the amended one, in order to support his argument. Let's see what kind of response that the EOCO boss will also give, and let's see how it goes. If that response is such that they will still want to continue to investigate the man, then Demolavo, if he still has a point, he can still go to court, as said by justice. He can still go to court and ensure that the appropriate body investigate him rather than EOCO. So
if the special prosecutor does the investigation, you'll be fine?
If that is the appropriate body, why should I?
The appropriate body is which? What's your?
Yeah, to my mind, it is the special prosecutor, and that is why I think the Attorney General is the right time for the Attorney General to. Because both the special prosecutor leadership, because as
all these institutions are really under her.
Yes, as we are discussing, it's not healthy for the fight against corruption, and we cannot sit back and watch this prolong beyond this stage. And that is why I think that the Attorney General should show some leadership by resolving this issue. And Section 81 of the Special Prosecutors, the Office of the Special Prosecutor Act clearly says that the Attorney General has the power to do some of these transfers.
She may be seen as interfering.
Well,
that's a probe already.
We are having a difficulty here. We are having a chaotic situation.
You can't expect her to go and direct EOCO that,
why not?
Give it to.
The law says she can.
She can. Okay, well, thank you, Justice. I'm grateful that you joined me. Thank you, Chairman, for joining me. Thank you, Vitus Azim, also for joining me. We'll see how this plays out. We're waiting to hear what EOCO's position will be to Daniel Demolavo's letter to him. Enjoy the rest of your evening.